California Real Estate Practice Exam. Question 1. Ayanna Dubois, a chef, rented property in order to run a restaurant in California. Dubois purchased and installed a commercial-grade range, oven, deep fryer, and grill. To comply with safety regulations and protect her staff, Dubois has securely fastened all of this commercial restaurant equipment to the kitchen. Which of the following is a correct statement related to the restaurant equipment Dubois installed? Dubois can remove this equipment from the property prior to the termination of the lease. Dubois can remove this equipment from the property, even after the lease is over. Because this equipment has been firmly affixed to the property, it is now part of the real estate. The lessor will determine whether or not Dubois can remove this equipment. A fixture is an item of personal property that is so firmly attached to the land or the building that it is considered part of the real estate and transfers with the deed. An important exception to this rule is the trade fixture. A trade fixture is something a tenant uses regularly in the course of the tenant's trade or business. Here, the commercial restaurant equipment that Dubois purchased and installed for her business is an example of a trade fixture that she will be able to remove legally prior to the end of the lease. B is incorrect. Typically, the tenant would need to remove a trade fixture prior to the end of the lease. After the end of the lease, the tenant would not even have a legal right to be on the landlord's property. C is incorrect. Answer choice C states the general rule for fixtures. But, because this restaurant equipment is used in the tenant's business, it will be considered a trade fixture that the tenant can remove before the end of the lease. D is incorrect. The lessor is the landlord. The rule related to trade fixtures is not dependent upon a decision by the landlord. Question 2. Which of the following is an example of the government's realty-related police power? The SWAT team breaking down the door of a unit in an apartment complex. A city changing the zoning from industrial to residential in an entire area. A county forcing owners out of their homes through eminent domain. The state without the prior owner's permission acquiring permanent title to realty through a cheat. Control over real estate and land use by a government entity is called public control. There are 4 basic governmental powers over real estate ownership and land use: police power, eminent domain, taxation, and escheat. Your memory aid is Pete. The government's police power over real estate includes things like zoning, building codes, city planning, public health, public safety, and general welfare. Answer choice B is a classic example of police power. Here, the city exercised its police power to enhance public health and safety by separating the new residential area from industrial activity. Escheat, eminent domain, and taxation are not part of the government's police power. The state examiners frequently write questions trying to trick examiners into incorrectly lumping one of these other 3 powers into police power. A is incorrect. A special weapons and tactics (SWAT) team uses specialized equipment and tactics to respond to criminal activity posing an elevated risk to the public or to law enforcement personnel. That's an entirely different type of police power. C is incorrect. Under the power of eminent domain, the government can take private property for public purposes, example widening a highway, but must pay the owner of the property just or fair compensation. In contrast, the government would not typically have to pay owners if there is a decline in value due to a zoning change. D is incorrect. The state can exercise its power of escheat when a parcel of real estate has been abandoned, or if the owner dies without a will and no heir can be found. After 5 years, the real estate permanently escheats and belongs to the state of California. Test-taking tip: the state examiners may try to trick you into lumping one or more of these 4 separate powers together. Question 3. All of the following are examples of lawful private controls on real estate except limiting the size of the American flag. Homeowners are permitted to fly on their property. Forbidding paint color other than beige on the exterior of a home. Promoting diversity through restricting sales to unrepresented races. Banning people from owning large dogs weighing over 40 pounds. Private control is exercised by a non-governmental entity. This type of non-governmental control is typically found in deed restrictions or covenants, conditions, and restrictions, CC and RS. Private control usually runs with the land. That means the restriction binds both current and future owners. The restrictions may be limited to a single parcel of land or they might cover an entire subdivision. In 1948, in the landmark case of Shelley v. Kramer, the U.S. Supreme Court held that the federal Constitution prohibits racially restrictive housing covenants in the United States. Therefore, limiting the sale of real estate to certain races, even with the goal of promoting diversity, is an example of illegal private control. Test-taking tip: restricting the sale or rental of real estate on the basis of race is never legally permitted in the United States. A, B, and D are all common examples of lawful private controls. Question 4. Late one afternoon, a listing broker was holding an open house at 125 Woodriver Drive in California. Seeing the open house sign, a prospective buyer came in to look at the home. After several questions about the house and local school system, the inexperienced buyer asked the listing broker for suggestions on how to negotiate successfully for the Woodriver Drive residents. The listing broker answered the questions as helpfully as possible. However, because the broker was tired, the broker did not raise the issue of agency representation, compensation, or even ask for the prospective buyer's name. The following morning, the prospective buyer started to act on the listing broker's advice. What type of agency, if any, was created with the prospective buyer? Implied agency. Express agency. An agency relationship cannot be formed without first learning basic information like names. Because compensation was never discussed, no agency relationship was created. In CA, an implied agency can be created unintentionally or by accident, and without any written formalities. By guiding the prospective buyer on the negotiation tactics needed to purchase the Woodriver Drive property, the listing broker was engaging in the advisory conduct that should be reserved for clients, thus accidentally creating an implied agency relationship. B is incorrect. An express agency is created by the oral or written agreement of both parties. Here, the test question states that the subject of agency representation was never discussed. C is incorrect. An unintended or implied agency can be created during a casual conversation where names have not been exchanged. D is incorrect. An agency relationship can be created without compensation being discussed, or without even the expectation of compensation. This is one reason why real estate licensees do everything possible to prevent an implied agency. An implied agency can create fiduciary duties owed by the real estate professional before there is any type of agreement related to compensation. Note: the listing broker was already the agent of the seller. By advising the prospective buyer and establishing an implied agency, the listing broker created an undisclosed dual agency with the seller and the prospective buyer. An undisclosed dual agency is illegal and will subject the listing broker to DRE discipline and the loss of any earned commission. Question 5. John Brown is the sole owner of a condominium in CA with a list price of $900,000. The listing broker learns that a prospective buyer, Samantha Sutherland, owes $75,000 in delinquent child support. Which duty owed only to the principal will require the listing broker to disclose the delinquent child support to John Brown? Honesty, good faith, disclosure, disclosure of material facts. In CA, disclosure is a fiduciary duty owed by an agent to a principal. Here, the agent is the listing broker and the principal is the seller. The listing broker owes the seller the disclosure of relevant and pertinent information pertaining to the listing broker's duties. One of the listing broker's duties is to counsel the seller as to a prospective buyer's ability to complete a sale. Information related to the delinquent child support must be disclosed by the listing broker to John Brown as it pertains to Samantha Sutherland's financial ability to buy the condominium. A, B, and D are incorrect. Real estate licensees owe both parties to a transaction the duties of honesty, good faith, fair dealing, and a full disclosure of all material facts related to the desirability or value of the property. Test-taking tip: be careful to distinguish the fiduciary duty of disclosure from the disclosure of all material facts related to the property. The fiduciary duty of disclosure is owed by an agent to his or her principal. The fiduciary duty of disclosure is not owed to an unrepresented member of the public. In contrast, the disclosure of all material facts related to the property is owed by a real estate licensee to both parties in a transaction, and does not depend on an agency relationship. Question 6. All of the following are correct statements related to a listing broker and a broker working as a property manager in CA except: both brokers owe fiduciary duties to their principals. Both brokers must supervise their associate licensees. Both brokers typically have a limited authority to bind their principals. A listing broker is a special agent, while a property manager is a general agent. In CA, the listing broker is a special agent, employed by the seller for a particular transaction or act, i.e., to sell the property. A special agent is typically only an advisory position. So, for example, while the listing broker can solicit offers and advise the seller as to the merits of each offer, the listing broker cannot accept an offer and bind the seller. In contrast, the real estate broker working as a property manager is a general agent. As a general agent, the broker/property manager would have a limited capacity to bind the property owner, example hiring repair and maintenance technicians, finding and renting units to qualified tenants, collecting rent, etc. General agents are typically employed for ongoing businesses. A, B, and D are correct statements. Test-taking tip: the salesperson or broker associate acts as a general agent to the broker of record. Question 7. What type of appraisal report is commonly relied upon in California by a lender financing the purchase of a single-family residence? Self-contained report, summary report, new subdivision public report, home inspection report. The summary report is an appraisal with a level of detail sufficient for lenders financing either the purchase or the refinance of residential property. The appraiser summarizes the information included in the work file of the subject property and reports an estimate of the subject property's market value. A is incorrect. The self-contained report, aka the narrative report, is the most detailed and comprehensive type of appraisal. The appraiser would report and explain rather than merely summarize the information in the work file of the subject property. C is incorrect. The public report for new subdivisions is not a type of appraisal. It is a disclosure statement issued by the DRE to inform the public about the new subdivision. With some exceptions, developers of new subdivisions of 5 or more units must apply to the DRE for the public report. Without a final public report from the DRE, developers are not allowed to close escrow on any real estate parcels in the new subdivision. D is incorrect. A home inspection report is not a type of appraisal. A home inspector reports on the condition of a property's major systems and components, example heating, air conditioning, electrical, plumbing, foundation, walls, insulation, etc. Question 8. Kim Nguyen owns a 3-bedroom, 2-bathroom single-family residence in California. Nguyen legally converted the master bedroom and bathroom into a separate granny flat for her elderly mother. The granny flat cost $50,000, but only added $30,000 in value to the property. Several years later, Nguyen remodeled the kitchen in the main house. The remodeled kitchen cost $15,000, but added $20,000 in value to the property. Which of the following statements is correct? The granny flat and the remodeled kitchen are both examples of decreasing returns. The granny flat is an example of progression. The remodeled kitchen is an example of regression. None of the above statements are correct. None of the statements are correct. A is incorrect. Per the principle of contribution, the value of an improvement, aka a component, is not what it cost, but what it adds to the subject property's value. The granny flat is an example of decreasing returns because it cost $20,000 more than it added in value. Answer choice A is incorrect because the remodeled kitchen added $5,000 more in value than it cost, making it an example of increasing returns. B and C are incorrect. These answer choices incorrectly use terminology from a different principle of appraisal, the principle of conformity. Per the principle of conformity, property values tend to stabilize when homes in a neighborhood are similar to each other. This principle theorizes that the value of a mansion in a neighborhood of small houses will fall, and this is called regression. By contrast, the value of a small home in a neighborhood of mansions will rise, and this is called progression. Question 9. This method of valuation is used for unique or historic properties, as well as new construction. It is frequently used when comparables are unavailable, and when the subject property does not produce income. In order to reach an opinion of value, the appraiser estimates the current cost to build a new improvement with the same utility, then deducts accrued depreciation, before adding the value of the land. This method of valuation is called the replacement cost approach, the reproduction cost approach, the market data approach, the income approach. This method of valuation is called the cost approach. It involves the appraiser estimating the cost to build the improvements new, deducting for accrued depreciation, and, finally, adding the value of the land. The replacement cost approach is used to estimate how much it would currently cost to build the improvements with the same utility, using today's materials and labor skills. The estimate would include a cure for any outdated design, i.e., a cure for functional obsolescence. B is incorrect. The reproduction cost approach would estimate how much it would cost to build an exact replica of the existing improvements, and the estimation would include not correct any outdated design. C is incorrect. The market data approach, aka the sales comparison approach, uses adjusted, recently sold comparable properties to arrive at an estimate of the market value of the subject property. If comparables or comps aren't available, the cost approach is an alternative method of valuation. D is incorrect. The income approach is used to appraise income-producing properties. The test question directs you to select a method of valuation for properties that do not produce income. Question 10. This security instrument is used for loans when the collateral is a parcel of real estate. It is legal, but infrequently used in California. The security instrument has only two parties and creates an encumbrance on the real estate. From the following choices, what is the security instrument called? Deed of trust, promissory note, mortgage, option agreement. A mortgage is a security instrument, legal but infrequently used in California. There are two parties, the borrower is called the mortgagor and the lender is called the mortgagee. A test-taking tip, the words mortgagor and mortgagee are tested on nearly everybody's state exam. The vowels in the words can serve as your memory aid. There are two ES in mortgagee and lender, and two OS in mortgagor and borrower. A is incorrect. The deed of trust has three parties, the trustor, borrower, the beneficiary, lender, and the trustee, third party, acting on behalf of the lender. B is incorrect. A promissory note is not a security instrument, but an instrument that documents the terms of a contract to pay back money lent at a specified time or on demand in a financial transaction. D is incorrect. The option contract is not used for loans. An option contract is typically between the owner, optioner, of a parcel of real estate and a prospective buyer, optionee, considering whether or not to buy the property. The owner promises not to sell the property to anyone else during the option term, and makes this promise for the non-refundable option fee. Test-taking tip, in the deed of trust, the borrower conveys bare legal title to the trustee. Why is this important? The deed of trust nearly always contains a power of sale clause. This clause gives the trustee the authority, on behalf of the lender, to sell the property if the borrower defaults on the terms of the loan, example, not making loan payments, letting the property fall into ruin, etc. However, if the loan is paid in full, the trustee must reconvey bare legal title back to the former borrower. Question 11. Kayla Chen and Christina Wang cannot afford the down payment on the 3-unit residence they want to purchase together in CA. They turn to a government program for assistance. Chen and Wang are required to purchase mortgage default insurance, but only have to pay 3.5% of the home's appraised value as a down payment. Chen and Wang purchased the home using a conventional loan from a lender with private mortgage insurance, PMI, a direct loan from FHA with mutual mortgage insurance, MMI, a VA guaranteed loan with mutual mortgage insurance, MMI, an FHA-insured loan from a lender with mutual mortgage insurance, MMI. Since it was created in the 1930s, the Federal Housing Administration, FHA, loan program has helped millions of Americans become homeowners when they cannot afford the down payment on a 1 to 4 unit residence. When a loan is FHA insured, lenders will agree to a loan-to-value ratio of up to 96.5%. The test question stating that Chen and Wang only put a 3.5% down payment on their newly purchased residence was one clue that their loan was FHA insured. This program of the federal government works by protecting lenders against loss in the event of borrower default. It does this through FHA mortgage default insurance. Borrowers must pay for FHA insurance, called mutual mortgage insurance (MMI). The FHA is not a direct lender. Borrowers would get the loan from FHA-approved lenders. A is incorrect. The test question states that Chen and Wang turned to a government program for assistance, but a conventional loan is not guaranteed or insured by the government. For conventional loans where the loan-to-value ratio is over 80%, the lender may require private mortgage default insurance called private mortgage insurance (PMI). This insurance would protect the lender in the event of borrower default of the loan. Typically, it would not protect the lender for the entire outstanding balance of the loan. Instead, PMI covers at least a portion of the deficiency between what is still owed on the loan and what the property sells for at the foreclosure sale. B is incorrect. FHA is not a direct lender. D is incorrect. The test question states that Chen and Wang had to purchase mortgage default insurance. The VA loan program is guaranteed by the government. Veterans who qualify for this government program do not have to purchase mortgage default insurance. Question 12. Dwayne Smith, a 25-year-old man, is purchasing a single-family residence in a newly built subdivision of 50 parcels in California. The residence is move-in ready. Because the other 49 lots have already been sold, Smith is buying the model home in the new development. The developer offers to sell the furniture in the model home along with the real estate. Smith, in the process of getting a fully amortized loan, discusses the purchase of the furniture with his lender. What is it called if both the real estate and the furniture serve as collateral for the loan? A construction loan, a term loan, a home equity conversion loan, a package loan. A package loan is secured not only by real estate, but also by personal property being sold with the real estate. Two examples of personal property that might be packaged with the real estate are 1. Furniture sold with model homes or vacation properties, and 2. Kitchen equipment being sold with a property used as a restaurant. Note, the legal term for personal property is chattel. A is incorrect. A construction loan is interim financing typically advanced in installments and used for construction. Here, the test question states that the newly built residence is move-in ready, meaning it is suitable for immediate occupancy without further construction needed. B is incorrect. A term loan, aka a straight loan, is an interest-only loan with a balloon payment at the end of the term when the borrower must repay the entire principal. However, the test question states that Smith is financing the purchase with a fully amortized loan. The fully amortized loan is characterized by equal payments throughout the loan term until the balance reaches zero. C is incorrect. In order to qualify for a home equity conversion loan, aka a reverse mortgage, federal rules require that a borrower be at least 62 years old. Dwayne Smith, a 25-year-old man, is too young to qualify for this type of loan. Test-taking tip: A reverse mortgage allows seniors to turn the equity in their homes into a liquid asset without having to sell. Seniors typically do not pay back the loan until they sell, die, or move into a nursing home permanently. The downside to this type of financing is that the interest accruing on the reverse mortgage is added to the loan balance. This growing debt is called negative amortization. Question 13. Juan Gonzalez, a veteran living in California, wanted to buy a single-family residence to live in as his home. He turned to the CalVet residential loan program in order to help finance the purchase. The financing instrument used in the CalVet loan program is an installment sales contract. Who will give Gonzalez a deed to the property? The owner of the home prior to the CalVet installment sales contract. CalVet. The vendee. Insufficient evidence provided to answer the question. The CalVet Residential Loan Program is a program available to veterans living in California to help them finance the purchase of their homes. Here is how this government program works. After the veteran has found a home he or she wants to purchase, CalVet will buy the property outright from the former owner and then sell it to the veteran using a financing instrument called an installment sales contract. In this government loan program, CalVet is the seller/vendor, and the veteran is the buyer/vendee. The installment sales contract is a form of seller financing where the seller will only give a deed to the buyer after the last payment has been made. Test-taking tip for the state exam: make sure you remember that, under an installment sales contract, the seller is the vendor and the buyer is the vendee. The vendor holds legal title and the vendee holds equitable title throughout the installment sales contract. The buyer only receives legal title and a deed to the property when the installment sales contract has been paid in full. An installment sales contract is also referred to as a land contract or a contract for deed. A is incorrect. When the last payment has been made under an installment sales contract, the vendor will give a deed to the vendee. Here, the vendor is CalVet and the vendee is Juan Gonzalez. C is incorrect. Under an installment sales contract, the buyer/vendee, Juan Gonzalez, would not deed the property to himself. D is incorrect. Calvet would have purchased the home from the former owner prior to entering into an installment sales contract with Juan Gonzalez. Question 14. James Johnson and Iko Johnson are married to each other. The Johnsons are in the process of purchasing a condominium together in CA. What is a way for them to hold title so that, when one spouse dies, the survivor immediately owns the condominium in severalty, as tenants in common, as community property with right of survivorship, as joint tenants, both B and C? Answer choices B and C both include what's called the right of survivorship. If there is a right of survivorship and one co-owner dies, the survivor immediately through operation of law acquires the ownership interest of the deceased. Answer choice B is only available to married couples or registered domestic partners. Answer choice C is available to married couples and registered domestic partners, but is also available to unrelated and/or unmarried people. When title is held in a joint tenancy, there can be more than 2 joint tenants on title at the same time. Test-taking tip: ownership in severalty is ownership with one sole owner on title. A is incorrect. If the Johnsons own the property as tenants in common, and one of them dies, the property would go through the probate court. Probate is a frequently slow legal process to distribute the assets and pay the debts of someone who dies. Test-taking tip: a person who dies after making a will is said to die testate. In contrast, a person who dies before making a will is said to have died intestate. Question 15. The escrow closing statement for a typical purchase transaction sets forth the debits and credits for both the buyer and the seller. Which of the following statements is correct? A debit to the buyer might include a new mortgage. A debit to the seller might include prepaid property taxes. A credit to the buyer might include buyer-paid discount points. A credit to the seller might include the property sale price. The escrow closing statement sets forth what each party must pay or will receive prior to the completion of the purchase transaction. A debit is what a party must pay to complete the purchase transaction successfully. A credit is what a party will receive prior to the transaction closing. The property's sale price is typically a credit the seller will receive before the close of escrow. A is incorrect. A new mortgage either from an institutional lender or through seller financing is considered a credit to the buyer. For example, buyer is purchasing a condominium for $1 million. ABC Mortgage Lending Incorporated lends buyer $800,000. Because of this new loan for $800,000 from ABC Mortgage Lending Incorporated, the buyer must only come up with $200,000 to complete the purchase of the $1 million condominium. B is incorrect. Prepaid property taxes are a credit to the seller. For example, if the seller has prepaid the property taxes for the entire tax year, and the buyer is moving in prior to the end of the tax year, the buyer must return a portion of those prepaid taxes to the seller. C is incorrect. A discount point is an upfront fee paid to the lender to decrease the interest rate on a new loan. If the buyer is paying 1 or more discount points to the lender, that would be a debit to the buyer, not a credit. Test-taking tip: 1 discount point is 1% of the new loan amount, not 1% of the purchase price. Question 16. 2 brokers secretly decide their brokerage firms will charge the same commissions and fees in California. They also quietly decide which counties each firm will service. These practices are illegal under the Federal Equal Credit Opportunity Act, the Federal Sherman Antitrust Act, the California Attorney-Broker Professional Conduct Act, the California Fair Employment and Housing Act. These practices are in violation of the Federal Sherman Antitrust Act. This federal law prohibits the anti-competitive behavior shown by the brokers in the test question, example, collusion, price fixing, and dividing up territories. California has its own antitrust legislation, the Cartwright Act. Antitrust violations under federal and California state law can result in, among other things, monetary fines and/or imprisonment. A is incorrect. The Federal Equal Credit Opportunity Act, ECOA, prohibits unfair lending practices. It was enacted in 1974 to ensure that adult consumers had equal access to credit without regard to their membership in protected classes like race, religion, color, sex, national origin, marital status, or age. Under ECOA, creditors cannot deny credit or a loan merely because all or a part of the consumer's income comes from public assistance. ECOA also requires the creditor explain why an application for credit was denied. There is nothing in the fact pattern to suggest an ECOA violation. C is incorrect. There is no California Attorney-Broker Professional Conduct Act. Test-taking tip: be prepared for the state examiners to make up laws and terms occasionally. That is why it is critical to study a comprehensive, current real estate glossary. Typically, you can find them at the back of your licensing textbooks. D is incorrect. The California Fair Employment and Housing Act, FKA the Rumford Act, is a state law that prohibits housing discrimination against protected classes. There is no indication of housing discrimination in the fact pattern. Question 17. 2 years ago, a tenant died in Unit 7 of an apartment complex in California. The unit is vacant, and the landlord shows a prospective tenant through the property. The landlord informs the prospective tenant that a previous tenant died in the unit 2 years ago from AIDS-related complications. Which of the following is a correct statement? Disclosure of a death on a property is only required for sales, not rentals. The landlord properly disclosed the death, but improperly disclosed the AIDS-related cause of death. The landlord properly disclosed the death, but disclosing a cause of death is never allowed. Disclosure of a death on a property is only required if it occurred within the past year. In CA, a death on a property being sold, leased, or rented must be disclosed if it occurred within the past 3 years. However, if the death was from AIDS or HIV related, the cause of death should not be disclosed. Under California Civil Code Section 1710.2, it is not even considered a material fact that an occupant was HIV positive or died from AIDS-related complications. Additional protection for those afflicted with AIDS or HIV positive can be found in the Federal Fair Housing Act amendments of 1988. The 1988 amendments categorized being afflicted with AIDS, or being HIV positive, as a handicap or disability. Because this affliction is considered a handicap or disability, the disclosure is considered discrimination against the handicapped/disabled, and is in violation of federal fair housing laws. A is incorrect. Disclosure of a death on a property is legally required in California for both sales and rentals, provided that the death occurred within the last 3 years. C is incorrect. Disclosing other causes of death is legally permitted. D is incorrect. A death on a property offered for sale or lease must be disclosed if it occurred within the last 3 years, not within the past year. Note, even when a death occurred more than 3 years ago, an owner and agent are not legally permitted to lie in response to a direct inquiry. Question 18. Which of the following is a lawful brokerage firm practice? Keeping $250 of the brokerage firm's money in the client trust account. Removing an earned commission from the client trust account after 60 days. Supervising associate licensees who were hired as independent contractors as employees. Steering. Under California real estate law, an associate licensee, i.e., a salesperson or a broker associate, is legally considered an employee of the hiring broker. Hiring an associate licensee as an independent contractor is relevant for tax and insurance purposes. But, it does not alter the level of supervision the broker of record must exercise over every associate licensee, whether they are hired as employees or as independent contractors. A is incorrect. A brokerage firm can legally keep $200 of its own money in the client trust account, as a buffer between client funds and any bank fees or service charges. The extra $50 reflected in the test question would constitute a legal commingling of the brokerage firm's money and the client's money. B is incorrect. Any commissions, income, or fees earned by the brokerage firm must be removed from the client trust account within 25 days. D is incorrect. Steering is illegal racial discrimination accomplished by guiding a client towards or away from a particular neighborhood. Example, showing a Hispanic client only those homes in neighborhoods with a Hispanic majority. Steering is prohibited by federal and state fair housing laws. Question 19. Jordan Smith is the broker of record at a brokerage firm in California with 5 associate licensees. All 5 associate licenses are very experienced salespeople. A mental health condition causes Smith to be incapacitated and hospitalized for long-term treatment. What is the status of the listing agreements at Smith's brokerage firm? The experienced associate licensees will handle the realty-related work at the brokerage firm. Smith's mental incapacity terminates the listing agreements. The associate licensees can continue to service the listing agreements, subject to supervision by the DRE, provided that a salesperson is shown as a party to the listing agreement. That specific salesperson can continue to service his or her clients. Smith's mental incapacity terminates the listing agreements at this brokerage firm. Test-taking tip: remember that the listing agreement is a contract between two parties, the seller and the broker. For the seller, death, mental incapacity, or bankruptcy of either the seller or the seller's broker will terminate a listing agreement. A and C are incorrect. No matter how much experience real estate salespeople have, California real estate law requires they be supervised by their designated broker for those activities requiring a real estate license. The licenses of all 5 associate licensees will be in canceled status until they are affiliated with a new broker. C is also incorrect because the DRE does not supervise the daily professional activities of real estate salespeople. D is incorrect. A real estate salesperson is not legally allowed to enter into a listing agreement with a member of the public. The two parties to the listing agreement are the seller and the broker. For the seller. Question 20. All of the following contracts must be in writing to be enforceable in CA except a lease of a parcel of real estate for a term of 1 year, a purchase and sale agreement for real estate, a listing agreement, an agreement by a buyer to pay a loan secured by a lien upon the real estate purchased. In California, the statute of frauds requires that certain contracts be in writing in order to be enforceable. A lease is a contract between the landlord and the tenant, and any lease with a term that is longer than 1 year must be in writing, example 1 year and 1 day. However, a lease of real estate for a term of 1 year or less does not need to be in writing. Test-taking tip: before the state exam, make sure to review the statute of frauds so that you know which contracts must be in writing to be enforceable. B, C, and D must be in writing to satisfy the statute of frauds.